Welcome. Welcome to the Radical New Me podcast. I'm Donna Gerald, and I am radical. I'm radical for righteousness, for truth, for justice, for peace. I'm radical for the things of God, radical for prayer, faith, healing. So today I speak truth, and I am calling on President Trump an urgent request from the president. Now, what I want to say is felony DUI and hit and run in South Carolina, there's a question. There's a question of classification and proportionality. What I'm requesting is there's a S-52 DUI bill. In almost 3 to 4 weeks, the session ends on May the 7th. And I need your help because I want to see justice prevail in South Carolina. Right now, South Carolina law is at stake. The South Carolina violent crimes list, the integrity of it is at stake. So my request is I want to amend this in the DUI reform bill, S-52. I want them to move felony DUI and hit and run from the South Carolina violent crimes list, no parole offenses, to a non-violent designation. As you can see, the core foundational issue we're talking about today is violent versus nonviolent. In the mid-1990s, during the sentencing reforms, there was a bill, the Federal Violent Crime Control and Law Enforcement Act of 1994. So South Carolina at that time expanded their classification, their violent crimes classification system. Now, it was incentivized by this 1994 bill, incentivized funding from the federal government to be harsh on crime, not smart or fair on crime. And I always say, follow the money, because this incentivized South Carolina to take felony DUI, car and boating, and hit and run, two crimes that have no intent, and put it on a violent crimes list full of intentional crimes. We want to take a look at before 1993 that these crimes, felony DUI, was involuntary manslaughter. It was 5 years max sentence, non-violent, and they served 50%, 2.5 years. Hit and run even had lower penalties, less structured penalties, not classified as violent, no 85%. And they recognized at this time what they actually are: impairment, poor judgment, tragic, accidental mistake, negligence. Now, after the mid-1990s, after the 1994 crime bill, what happened was these two crimes were put on that South Carolina violent crimes list and became 25 years violent, served 85%, no work, good behavior credits, or no parole. The result that we're going to see here is huge discrepancy, because these crimes moved from 5-year max to a 25-year max. I want to repeat that. Used to be 5 years, thrown onto that South Carolina violent crimes list, and became 25-year max. 2.5 years were served before. Now you're looking at 21.25 years, which is 85% of the 25 years. 5 times increase in punishment. 5 times. No parole eligibility, and they were now in the same category as intentional violent crimes. They were beside the murderers and the armed robbers and the child molesters and the rapists and all of these intentional violent acts. Now, legal expert perspective here. The U.S. Supreme Court in 2004 and 2008, in 2 cases, ruled that even if injury or death, a DUI is not to be a violent crime. And they also said that it was negligence and poor judgment, that there was no violent force. Now, SCDC Director Brian Sterling in 2019 at a legislative meeting. He said about felony DUI in South Carolina, he said they have no pattern of criminality. He said they come in just with nothing else but DUI. And then he said they don't get in trouble, and when they leave, they don't come back. Now, I don't know about you, but that sounds like a role model nonviolent inmate. Solicitor Stumbo in 2019 at a Senate Penology Committee said, no violent people, they're not violent. And he said they're no threat to the public. Senator Tom Davis, 2025 at a subcommittee, stated no mens rea. Mens rea means that you want to hurt somebody, and they have no mens rea. They do not want to harm or hurt. Senator Stubbs, 2025 at the same subcommittee meeting. There is a difference, he said, between someone that shoots someone and someone who got drunk and got behind a wheel. Senator Stubbs looked at that violent crimes list, and 2 crimes stuck out like a sore thumb. He pointed them out, felony DUI and hit and run. Little did he probably realize that those were the 2 crimes that were added way back after the 94 crime bill to be incentivized by federal spending to throw them onto a violent crimes list. He said the rest of this is bad stuff. Now, what we want to talk about is what we're concerned about here. These offenses, these do not involve intent to kill. They are the result of unintentional actions, never dreaming that they would get in a car and have a car accident or hurt anyone. They lack malice and they lack premeditation. I want to tell you about hit and run. The criminal conduct of hit and run is leaving the scene of the violence. I'm going to repeat that. What they're punishing you for, the criminal conduct, leaving the scene of the accident. You panicked, you weren't thinking straight. There's a friend of mine that left and ran home to grab his cell phone he didn't have in his car and called the police to report it. And he ended up getting 12 years in the worst prison in South Carolina. And he lost his broker's license, never got it back. He's now a violent felon the rest of his life for leaving that scene. There's no violence involved there. So hit and run should not be on a violent crime list. Yet, they are classified, as I said before, murderers, armed robbers, kidnappers, rapists, and child molesters. Now, why is the current policy or the sentencing not working in South Carolina? I want to say to you that these crimes, harsh penalties, will never prevent a crime if the person never had any intent to commit that crime. And South Carolina is number 1 in the nation in DUI deaths. Number 1 in the nation in DUI deaths. So we know that the unfair lengthy sentencing in the end is not working. It's not lowering these deaths. The answer is to close loopholes in the front and to get drunk drivers off the road, preventative. Now, also alcohol use disorder. Medical University of South Carolina can do a brain scan, and they can look at your brain scan and know if you have alcohol tendencies. So here we see that medically, they can tell you, watch out, because you can be that one person that gets hooked, addicted to alcohol because of the chemical makeup in your brain. And the brain scan clearly shows. And so AA, of course, we know calls this a sickness. Now, NHTSA, National Highway Traffic Safety Association, they classify DUI along with texters as distracted drivers. And so what they say is there's the same outcome. There's injury or death. They both do the same thing. You've seen it. They swerve in the road. They run a stop sign or a red light. So the drunk drivers, impaired drivers, and texters with their phone addiction, they're doing the same exact crime as your drunk drivers. But we don't think of them as violent criminals because we know they're not. This is poor judgment, distracted driving. I want to do a regional comparison with the Fourth Circuit states. our sister states. And what we see is they're all nonviolent. And we have North Carolina with a 17-year max, but they're nonviolent, so it's 65%. And then they get credits and parole if they behave and do the work. Then they can get to 51%, which is half, which is 8.5 years. North Carolina keeps offenders in prison the highest out of the Fourth Circuit, which is 8.5 years. But we have Virginia, 10 years, so they're in prison 5 years. West Virginia, we have 15 years, so it's 7.5 years. And then Maryland is 5 years, so it's 2.5 years. So you've got 2.5 years, 5 years, 7.5 years, and North Carolina with 8.5 years. We'd love to be like North Carolina. Now, most every state in our nation, we did charts, is nonviolent. Very few. South Carolina, along with one other state, is the harshest in the nation. It's extreme. It's outlier with the 25-year max, 85%. There are a handful of others, but they have lower max, like 15-year max. And so 12.75, they keep their offenders. And that's still a huge discrepancy between 21.25 of South Carolina. But only just a few are violent. Every one of the others are much lower max sentences and nonviolent with credit and parole. Now let's talk about the reality of this. Many impaired drivers die themselves or their loved ones in their car. And we know that they are not seeking to go find someone to hurt, and they're not seeking to harm anybody when they got in that car. And so we want to say that alcohol is highly deceptive. And we know that alcohol causes one to have an inability to even make a wise decision. And we also know that it impairs their judgment. So they think they're okay to drive, but they're not. But they are non-violent criminals, never, ever dreaming or any type of violent motive or intent in their hearts. The real solution, as I said earlier, is prevention before that tragedy happens. We need to, on the front end, close the DUI loopholes and remove them off of our highways. Recommendation is to move felony DUI and hit and run. Never should have been added years ago onto that South Carolina violent crimes list. The integrity is at stake. They do not belong there. And so we're asking to move it from that list, those two crimes, to a nonviolent designation. Now, not every tragedy is a violent crime, as you can see. Intent is what matters. There is no violent intent or motive in a car accident. It is an accident. Classification does matter, and justice must be proportional. So my closing statement, President Trump, I just need your help because I want to see South Carolina do what's right and fair and just and change this unjust law. What's unjust today was unjust yesterday, and I would like to see all those affected that benefits would be restored, and I'd like to see hope, and I would like to see redemption for those under this unjust law that needs to be corrected and changed. And we only have 3 to 4 weeks before our session ends, and I'm crying out to President Trump, to every single South Carolina legislator, and I want you to do the just and right thing and correct this misclassification. Do what is fair and proportional. So you have an opportunity, South Carolina, to move to what is smart on crime, smart and fair on justice. Thank you, and God bless.
The radical new me. The radical new me. Living the life God called me to be. Thank you for joining us on the Radical New Me podcast. Keep choosing losing faith.